Unnikrishnan vs. State of Andhra Pradesh, AIR 1993, SC 2178. This significant case, decided by Constitutional Bench of Supreme Court, laid the foundation for right to education as a fundamental right under Indian Constitution.
Subscribe the channel and hit the bell to not miss any update.
Facts of the case. This case involved some writ petitions filed by certain private professional educational institutions challenging the constitutionality of state laws regulating fee charged by such institutions. These institutions argued that they have the fundamental right to establish self-financing educational institutions, which can be regarded as business venture under Article 19, Clause 1, Subclause G, where it is provided that all the citizens of India shall have the right to practice any profession or to carry on any occupation, trade, or business. Moreover, they argued that where there is no subsidy or aid provided by the government, the cost of educating an engineer or a medical graduate is very high. It would discourage private initiative in providing educational facilities, particularly for higher education. Moreover, it was also stated when the government grant recognition to private educational institutions, it did not create an agency to fulfill its obligation under the Constitution. Questions of law. Firstly, whether the right to life granted by Article 21 includes the right to education or not. Secondly, whether there is a fundamental right to education for a professional degree that flows from Article 21. Thirdly, whether a right could be recognized as a fundamental right, even though it is not expressly mentioned. Fourthly, whether private unaided affiliated educational institutions running professional courses like engineering and medical courses entitled to charge a fee higher than that charged by government institutions. The Constitutional Bench giving the decision of this case consists of Justice B.P. Jeevan Reddy, Justice S.C. Agarwal, Justice S. Mohan, Justice S.P. Bharucha, Justice S.R. Pandyan. Decision of the Court. The Supreme Court held that the right to education is implied by the fundamental right to life provided under Article 21 of the Constitution when read along with the directive principles of state policy on education provided under Article 41. The court held that the parameters of the right to education must be understood in the context of the directive principles of state policy, including Article 45, which provides that the state is to endeavor to provide within a period of 10 years from the commencement of the Constitution free and compulsory education for all children under the age of 14. The court ruled that there is no fundamental right to education for a professional degree that flows from Article 21. Supreme Court, however, held that the passage of 44 years since the enactment of the Constitution had effectively converted the non-justiciable right to education of children under 14 years of age into one enforceable under the law. Moreover, the Supreme Court said the right to free education is available only to children until they complete the age of 14 years. Thereafter, the obligation of the state to provide education subject to the limits of its economic capacity and development. In addition, the court said that in order to treat a right as fundamental right, it is not necessary that it should be expressly stated as fundamental right in Part 3 of the Constitution. The provisions of Part 3 and Part 4 are supplementary and complementary to each other. The court rejected the view that the fundamental rights provided in the provisions of Part 3 are superior to the moral claims and aspirations reflected in the provisions of Directive Principles of State Policy provided in Part 4 of the Constitution. Regarding private unaided affiliated educational institutions running professional courses like engineering and medical courses, Supreme Court held that they are entitled to charge a fee higher than that charged by government institutions, but such a fee cannot exceed the limit fixed in this regard. However, commercialization of education is not permissible. Apart from it, the Supreme Court also said that if those institutions needed finances, they must find them through donations, etc., and could not say that they would first collect fee and with that money they would establish an institution. Only the bare running charges could be charged from the students if those institutions are suffering from financial crisis, and the capital loss could not be charged from the students. The professional institutions can admit NRIs to the extent of only 5% of their total seat capacity, but the fee payable by such students shall be as prescribed. The outcome of this case was that in MC Mehta versus State of Tamil Nadu and others, the Supreme Court stated that Article 45 had acquired the status of a fundamental right following the Constitutional Bench's decision of Unnikrishnan. The significance of this case was that the state responded to this declaration of Unnikrishnan case 9 years later through the 86th Amendment to the Constitution by inserting Article 21A, which provides for the fundamental right to education for children between the ages of 6 and 14, which was implicit under Article 21. Thank you so much for giving me your valuable time. If you have any doubts, do let me know and I'll try in the best possible way to clear those doubts, and subscribe to the channel as I'll be posting regularly such law contents. Till then, I'm Ricky, signing off.